direction of travel of a bullet. In short, he had no basis to formulate the opinion that these arrows were somehow indicative of anything important with respect to the bullets that were fired and whether or not and what those bullets mean and the puffs of smoke mean. Thank you.
Mr. McMahon.
Thank you, Judge. One of the issues that the jury is going to have to consider and decide is how many times Laquan McDonald was struck by a bullet. And this testimony, when it's combined with Mr. Patterson and Dr. Arun Kumar, will absolutely go to the issue of, was Laquan McDonald struck by 16 bullets? This was an issue that was before this court in People v. Degorski, and the appellate court addressed this exact issue. As in Degorski, this evidence is highly probative where the jury, as a finder of fact, is charged with considering where the 16 bullets landed. Mr. Messick, Mr. Patterson, and Dr. Arun Kumar, when their testimony is combined, will clearly show that Laquan McDonald was struck 16 times. The enhanced video, the slowed down video at 1/4 speed, and the identification of the puffs of smoke, all considered together, will assist the jury in making that determination. And I'd ask that you reconsider your ruling from yesterday. Thank you.
Thank you. Is the pathologist in Cook County at this time with the medical examiner?
Yes, she is. Dr. Arun Kumar is the chief medical examiner. She'll be here at 10:30 this morning.
Okay, good. Thank you for that update. All right, first off, after the basic foundational evidence has been laid for an expert witness, the next criteria, and this is the one that the Supreme Court of our state and the appellate courts have held, will the expert witness's testimony aid the jury in understanding the evidence? Yesterday, the expert caused confusion, all right? First of all, he shouldn't have been testifying about the arrows on this, the video, the enhanced video. The first interpretation was that was the paths of bullets. And if you looked at it as a semi-hemisphere, the bullets were coming from both the east and the west and also vertical. So, and then the other thing is, if he was the expert, he could have put annotations on the arrows saying this is a puff of smoke rather than the misinterpretation of the direction of the bullets of entry or exit. Then the other thing is, any expert can testify about another expert's conclusions and report if that expert, first of all, they have to be in the same field. If that expert has done independent research and independent corroboration in reaching his opinion about the testimony that the testifying expert will give. Here we had Mr. Messick testifying that the ballistic expert helped him and other things. He was testifying about an opinion of another expert, and he wasn't, and Mr. Messick was not in the field of that ballistic expert. So that should have never been allowed, all right? He did not aid in the understanding of the evidence to the jury, all right? What I'm going to do before I make a decision, I want issues conference at this time. Let me have 2 attorneys from each side. All right, there'll be a short recess.
Including Mr. Patterson and Dr. Arun Kumar.
All right. And defense, this has been agreed to, is that correct?
Yes, Judge.
And you've consulted with your client, and this is trial strategy, is that correct?
That's correct.
Thank you very much. All right. That will be the order. All right. So the motion to reconsider will be sustained under those conditions. All right. What I am going to do then is, before Mr. Messick retakes the stand, inform the jury that his testimony from yesterday is completely stricken, that it is not any evidence, and that they based their conclusions on discussions on the evidence that has been presented in this courtroom when he testifies after that instruction. At this time, bring our wonderful people out, please.
All rise for the jury.
Okay, will everybody please be seated? Good morning, ladies and gentlemen of the jury. All right, you got that energy. I want to hear that. That's good. You've been doing an outstanding job, and I just want to compliment you on that. Everybody's been paying attention, so really keep up the outstanding work you've been doing. All right, I'm going to go through the questions I told you I'm going to ask every day. So I'm going to ask both two questions. Did anybody discuss this case in front of you, or did anybody discuss this case with you? We started getting a little bit of a rhythm yesterday, and everybody was, at the latter part of it, everybody was saying, no, that's very permissible. So you don't have to wait for me to ask each question. So, all right, here we go. Let's change the order. Juror number 256. Did anybody discuss this case with you, or have anybody discussed this case in your presence?
No.
Thank you. You're my people. All right. Juror number 255. Same questions?
No.
All right. Juror number 254?
No.
Thank you. Juror number 253?
No.
Outstanding. All right. Juror number 252?
No and no.
Juror number 251?
No.
Juror number 250?
No and no.
Juror number 249?
No.
Juror number 248?
No and no.
Juror number 247?
No.
Juror number 246?
No and no.
Juror number 245?
No and no.
Juror number 244?
No and no.
Juror number 243?
No and no.
Juror number 242?
No and no.
Juror number 241?
No and no.
Juror number 240?
No.
So your brother-in-law didn't say nothing? All right, we're making progress. All right, it's just going to be a very short recess, and then we'll begin evidence. So thank you very much.
All rise for the jury.